As you know, gentlemen, each party will have 15 minutes to present for argument. Appellant proceeds first and may reserve up to 5 minutes for rebuttal. If you wish to reserve any time for rebuttal, please let me know as I'm keeping time today.
Okay. Yes, Your Honor. May I please have 3 minutes for rebuttal?
Very well. We read the briefs. We're ready to proceed.
May it please the court, my name is Tom Karras. I'm an assistant county prosecutor from Medina County, and I represent the Litchfield Township Board of Trustees in this matter, the appellant. This case has been before this court 3 times. This is the 3rd time before this court. This is the first time that the Board of Trustees have filed their appeal. This is a very awkward and troubling to I think both parties, very troubling matter because the facts are so convoluted as opposed to most of the cases that we see regarding prescriptive easements. This is a case where political subdivision has a property, and it can be described as a parking lot, as a driveway for their town hall and for their community center. The plaintiff's property abuts to the rear of this property. Now, this property was accumulated by the township over a series of transactions. The first being sometime in the late 1800s, where the town hall was actually created, and then in the 1950s, an additional parcel of land was purchased in back of the town hall, and at the time was used as a fire station, but is now they use as a community center as they built a more modern fire station since then. And then there was a third parcel, and that's the subject of this action. There was a third parcel. That third parcel was a strip of land along the back of the property, which was used by the township to extend its parking lot. It was also used to create a storage facility, like a garage or a barn, to maintain the township's road equipment and lawn equipment. And this is the parcel that we're here on today. This is a parcel that runs and butts onto the plaintiff's property.
Excuse me, is the time of purchase or acquisition of that parcel by the city critical to this case?
Yes, it is, Your Honor. That parcel was actually purchased in 1999, and according to the allegations of the plaintiff, that this prescriptive easement vested prior to the purchase of it. As we have cited in our brief, the case of 1540 Columbus Corp versus Cuyahoga County clearly states that, and it spoke about adverse possession, but it's just as relevant to prescriptive easements, that if a political subdivision is using the property for a public purpose, that adverse possession or prescriptive easement will not vest. And in this case, the property purchased in the 1800s, the property purchased in the 1950s, that certainly is the case. Now, because this property, to answer your question more fully, Judge Whitmore, because this parcel that's the subject of this, the reason the date becomes relevant as to the purchase is because the plaintiff is alleging that the easement, that the actions which give rise to this this prescriptive easement occurred prior to 1999. And unfortunately, the plaintiff took title to the property that was the subject of this action in 1980. So it couldn't have, on its own, the plaintiff could not have, by its own actions, the plaintiff could not have ever had a prescriptive easement, because a prescriptive easement requires 21 years of open and notorious use. And it only had title for 19 years at the most. Now, prior to 1980, that property was held by his father, Mr. Rising's father, and Mr. Rising's mother. And he obtained that property as the heir to the estate of his father. So in order for him to prevail in an action for prescriptive easement, he would have had to attack. He would have had to attack the use of his parents to his use. And that use must be of the same manner as Mr. Rising's. Well, there was testimony that they were used, that property was used, for lack of a better term, as a shortcut. There's State Route 18 and there's State Route 53. 53 is the plaintiff's property is on Route 53, and to go out to 53 and then get to 18 would mean that it would have to go all the way around the town hall.
So you're saying that the parents' use was simply private and didn't involve a commercial enterprise?
Absolutely.
And that therefore, because the present use is commercial, there can't be a prescriptive easement.
Right. The manners are not similar. There can't be tacking. There can't be tacking because the uses are not the same. You know, there was evidence.
Is use defined as how much time you spend encroaching on the land, or the purpose of why you are crossing the land?
I think time is an element to it. Obviously, it needs to be continuous. However,
Well, let's say, is it half an hour a month versus 20 hours a month?
we didn't get into that.
Okay.
Though there was evidence that it wasn't on a daily basis, but it was on an occasional basis. In fact, there was testimony that the plaintiff himself, prior to 1980, was not living on the property, and that he occasionally visited his parents, and he saw his parents using the property as ingress and egress, as a shortcut. The trouble with using it as a shortcut was that they could never get the prescriptive easement, or Mr. Rising could never get the prescriptive easement that he's actually seeking. He actually seeks, whether it's for the convenience of his customers or his suppliers, or whether for his own convenience or the convenience of his business, he can never get a prescriptive easement on the property for the purposes that he wants, ingress and egress. He wants to be able to take a shortcut and get onto Route 18. Well, he can never do that. He can never get that prescriptive easement. And even if we say that it doesn't matter if it's commercial or whether it was commercial or whether it was for personal use, it doesn't matter. The purpose that he was using this particular property was for ingress and egress.
Well, but isn't that the same purpose for which the Rising seniors were using it?
Well, yes, except that the problem is that he can never get that type of an easement. because his right, his supposed right would be only to the property line between the parcel that was bought in 1999 and the parcel that was bought in 1955. So what ends up happening is that the most he can do is he can't park on that property. It ends up being a strip of about 16 feet wide, about the 2 car widths. And it ends up being 16 feet wide by 40 feet long. And that's the only thing that he's getting the easement for. And that's what the problem with it is. So the most he can do, he can't park on it, he can't go over to the other to the other property. That would constitute a trespass. But the only thing he could do was maybe he can pull in and pull back out as some sort of way to reposition his vehicle. But that's not what the use was prior. So unfortunately, this is one of those cases of bad facts make bad law. You know, the old adage, bad facts make bad law. The most he can get, even though he may have used it, if this court finds that, oh no, commercial, the distinction isn't between commercial and private use, the distinction is between whether it's ingress or egress. Well, he can never, that easement that he would be awarded would not give him that, would not be for the same purpose. It would be for a different purpose.
Well,
At most to be to reposition your automobile or your vehicle.
The trial court, I'm not sure, agreed with you in ordering the township to remove the barriers. And it's not clear to me from the briefs whether that's the barrier to get onto that strip or the barrier to prevent what you refer to as a trespass onto the township's property.
Okay, thank you for the question. The only barrier that is there today is a fence, and that is on the property line. So it's access to get to the 1999 property. There is no barrier between, but in essence, and the reason that
Let me just stop you for
Okay.
just a moment. You answered my question, but you are at your 3-minute mark. If
Okay.
you wish to continue your presentation, you may do so. I just wanted to alert you.
no, I will simply ask that the appellate's appeal be affirmed and that it be remanded back to the court for appropriate disposition.
Thank you.
Thank you, Your Honor. Ted Lesiak, representing Robert Rising, the appellee. First, I'd like to address a procedural issue. The appellant's brief was filed out of time in this matter. Basically, the record was filed on February 17th, 2016, which would make the appellant's brief due on the 1st of March, 2016. On the 16th of March 2016, the appellant filed for a motion for extension of time to file a brief, which is an improper motion before the court. At that point, since the brief was late, it should have been a motion in stanter, and at that point, the appellant would have to show good cause as to why. After we responded, the appellant did file a motion in stanter with the brief on March 25th, 2016. The cause shown in the motion by the appellant was that they were unaware that the transcript of proceedings had been filed with the record. Well, that is against court rules. Appellate Rule 14 basically states in the rule itself that when you receive notice of the record, that all of the documents from the court, as well as the transcript of proceeding, has been filed. And as a result, we're once again requesting that the brief be stricken from the record and that the appeal be dismissed. Now, to address Mr. Karras' arguments before the court, first, the issue with regard to the so-called trespass property, the property that is actually not part of this case. There is absolutely nothing in the record with regard to the use of that property with regard to this easement. We're talking about the strip of land, and we're talking about ingress and egress. And what the trial court granted was prescriptive easement to Mr. Rising for ingress and egress, and asked them to remove the barrier between Mr. Rising's property and the strip of land belonging to Litchfield Township, directly adjacent to his property. We're not talking about any other properties belonging to Litchfield Township.
But ingress and egress suggests, by the use of the term, that you go onto and come in from. And so is this an invitation, if we're not talking about ingress to or egress from a public road, then aren't we just sort of setting ourselves up for the next lawsuit?
Well, we can't have another lawsuit. Mr. Karras is correct that the property that's the next Litchfield property was purchased at a time before there was any issue with regard to the prescriptive easement. So, but there is also no barrier there at the time, as Mr. Karras has told you, that's used for public ingress and egress to the Litchfield Town Hall. Now, I suppose Litchfield could take the barrier out and set it back 40 feet in the middle of their driveway there, if they choose to. I would find that to be counterproductive to Litchfield's purposes. If they were to do that, they would prevent the public from using their driveway. But with regard to the same or similar use issue, first of all, we're talking about ingress and egress, and that's what the easement was for. By definition, that means that Mr. Rising was granted the ability to leave his property with a vehicle and to come back onto his property with a vehicle from the easement property itself.
And did that right include other than personal use with a private vehicle, a small vehicle, as opposed to trucks carrying
No, it did not.
a heavier weight?
No, Your Honor. The trial court's order itself granted Mr. Rising personal use of the easement. Did not say anything about commercial use. And the personal use is because there's testimony in the record in several places that Mr. Rising stated that this easement or the ingress and egress was personal over the many, many years that his parents used it and the years that he used it.
And I take it there's substantial law that distinguishes between personal use being less burdensome than commercial use, and that therefore personal use does not establish a prescriptive easement for the commercial.
Actually, I don't believe there is substantial law on that issue. However, the commercial use is not really an issue before the court because that wasn't granted by the trial court.
And I understood from your brief that Mr. Rising testified and was asked what the measure of the use or the frequency of any commercial use, and he said on a couple of different occasions that it was extremely infrequent.
Yes, and actually where this comes from is Mr. Rising has a business on the property where he sells firewood. And trucks would come in from Route 83 onto his property at times delivering wood to be cut by Mr. Rising and sold. And rather than backing out onto 83, they would sometimes use the easement and go out through the township property. But he said that was infrequent. What he was talking about was basically his ability to go onto the property himself, and guests obviously, or others visiting, because there was testimony in the record that with his parents' use, that people who belonged to the fire department, the volunteer fire department, would use it at times. People who were visiting would use it at times. But we're talking about personal use. We're not talking about commercial use. And as I said, and I don't believe that's really an issue, but even if it were, with regard to same or similar, it is still vehicular traffic. Okay, that wasn't addressed by the court, but it's still a same or similar use, even if it were a truck rather than Mr. Rising's personal vehicles.
Well, but to Judge Whitmore's point, there is a difference between having a large logging truck carrying heavy tree or trees, and the maintenance of the property and the damage that can be done. There's a difference between that, if that were done frequently, and automobile traffic. Would you agree with that?
I would agree with that. And that's why I'm saying I don't really believe that's an issue that this court needs to determine, because the easement that was granted by the trial court is for personal use, not for commercial use. As a result, we're requesting that, based upon the record, that there is clear and convincing evidence, unrebutted clear and convincing evidence of Mr. Rising's personal use of this easement. Tacking really isn't an issue. This court's already determined that issue. And that the appeal should be denied and the judgment of the trial court should be affirmed. Also, and to go back, we believe that the brief of the appellant should be stricken from the record and the appeal dismissed. Thank you very much.
Counsel, you have about 2.5 minutes.
Thank you, Your Honor. I won't spend a lot of time on the procedural issue, other than to state that the discretion to give a large amount of time is the court's, and it should be given freely. And it amounted to harmless error simply because local rule 18A affords the appellants to file a certificate of extension of time, and the filing of this brief was well within that time that they would have been afforded for a certificate of extension of time otherwise. So it's harmless error, and it's not an abuse of discretion for this court to allow the brief to be filed. Just very simply, your question, Judge Moore, regarding doesn't this invite another lawsuit? That's exactly what will occur. The first time that it's used for commercial use, and in actuality, the testimony of Mr. Rising was that, yeah, customers did use it, suppliers did use it, and it was, first he said occasionally, but then he said regularly. So it wasn't an infrequent kind of thing, it was a regular kind of thing that customers used it. Trucks loaded with firewood, they would go through that. And also, when we're talking about these logging trucks that the suppliers use, they're not a pickup truck filled with logs. They're these big, huge semi-tractor trailers with a log that might be 40 feet long or 50 feet long, and weigh tons. And that's what was coming over this property. And originally, it needs to be heard that originally the reason the barrier was put up was that they had an audit done by their insurance company, and their insurance company saw that this community center, and they saw children coming out of this community center, and then they see these commercial vehicles and these trucks literally coming what amounts to a blind spot. It comes around it has to come around the town hall, and then you're right on the children.
And you have reached the end of your time.
Okay. Again, we would ask that the appellant's appeal be affirmed and remanded to the court for further proceedings.
Thank you, gentlemen. Thank you both for your presentation.
Thank you.
The court will take the matter under advisement and will issue an opinion which will be sent to both sides. And do check the Supreme Court website for